We all believe in fair access to justice, right? I mean, it's a cornerstone of any real democracy. But what happens when the very people in charge of the paperwork, the gatekeepers of a state's highest court, are accused of rigging the game? So today, we're going to dive into a multi-year conflict that raises some really serious questions about the integrity of the Supreme Court of Victoria.
Now, you might think this is a line from some gritty legal drama, but it's not. This is a direct quote from a real litigant, Shivish Kuksal, in a letter to one of the most senior administrative officials in Victoria's entire justice system. It's a statement that just cuts right to the heart of an absolutely explosive set of allegations we're going to be breaking down.
All right, so let's break down who we're talking about here. On one side, we have Mr. Shivish Kuksal, a self-represented litigant, and he's going head-to-head with the Office of the Prothonotary of the Supreme Court of Victoria, which is basically the central administrative hub of the court. And this isn't just about one case, it's about the very process of justice itself. To really get the gravity of this, you have to understand this role. The Prothonotary, they aren't a judge, but they hold an immense amount of power. They are the gatekeeper. They manage the flow of all the documents, they make sure all the procedural rules are followed, and they maintain the official court record. I mean, their impartiality has to be absolute. It's non-negotiable. And look, this whole conflict we're digging into, it isn't based on rumors or hearsay. It's built on years and years of documented correspondence, with Mr. Kuksal making a series of increasingly serious allegations against the protonotary, a Mr. Rod Ratcliffe and his office. So the first big issue that just jumps out from all this paperwork is this pattern of, well, alleged unequal treatment. The claim is that the court's administrative arm basically created a two-tiered system of justice, with one set of rules for some people and another set of rules for others.
So how did this actually play out? Well, a specific directive was issued to Mr. Kuksal. No more phone calls, period. All communication with the court registry had to be in writing. Now, for anyone who's ever had to deal with an urgent legal matter, you know that being able to pick up the phone can be absolutely critical. This restriction effectively cut him off from a standard channel that was open to everyone else. But here's where it gets really, really interesting. What was the official reason for this? In an email, the protonotary, Mr. Ratcliffe, explained that this special rule was applied because Mr. Kuksal was, and I'm quoting here, a very sophisticated self-represented litigant. So get this. His own competence was used as the justification to give him less access, not more. It's a pretty bizarre line of reasoning.
And, this wasn't just a one-off thing. The source documents show that the deputy prothonotary actually conceded in writing that a policy existed where all filings from self-represented litigants were funneled exclusively to the prothonotary himself for review. And the impact of that? Well, they admitted it themselves. It added a systemic delay of an extra 2 working days. That's a huge disadvantage when you're up against well-funded opponents. Okay, this all leads up to one single day, October 7th, 2025, which honestly gives us this dramatic minute-by-minute picture of these allegations of preferential treatment in action. Just look at this timeline. At 9:45 in the morning, Mr. Kuksal lodges his summons. Throughout the entire business day, it gets knocked back again and again for different technical reasons. Then, get this, after hours at 6:31 p.m., a state body, the Victorian Legal Services Board, or VLSB, lodges a similar document. By 6:38 p.m., it's officially sealed by the court and served. 7 minutes. Let that sink in for a second. After the court was officially closed for business, a state body gets their papers processed and approved in just 7 minutes, while Mr. Kuksal's documents, which were lodged that very morning, were still sitting on the rejected pile.
And this is really the heart of the complaint, right? The documents show that one of the reasons his filing was rejected was because it listed multiple proceeding numbers. But the VLSB's summons, the one that was approved in that 7-minute window, it did the exact same thing. It's just a really stark example of what looks like a blatant double standard.
So we've gone from unequal treatment, but now the allegations escalate to something way, way more serious. The claim that the protonotary's office deliberately tampered with the official court record. This is an accusation that strikes at the very heart of judicial integrity. Okay, take a look at this. This might be the most startling piece of evidence in the whole thing. On the left, you have an affidavit, that's a sworn legal document, describing events that happened on November 15th, 2024. But on the right, the official court seal, the stamp that says when it was filed is dated June 28th, 2024. That's nearly 5 months before the events it's describing even took place.
So the question is obvious. How on earth can a document be filed 5 months before the things in it even happened? Well, according to the source documents, Mr. Kuksal alleges this wasn't some typo. He claims it was a deliberate backdating of the file, done by manually overriding the court's electronic system. And the alleged purpose? To make it harder for journalists and the public to access the document in the correct timeline.
So you might be thinking, okay, why does one person's fight with a court administrator matter to the rest of us? Well, it's because these allegations, if they're true, they don't just point to a single problem in a single case. They point to a potential crisis of trust in the very foundation of the rule of law.
The source analysis report really breaks down the systemic threat here, and they are huge. We're talking about an administrator potentially taking on the power of a judge, about completely destroying public trust in what should be sacred records, and about the systemic denial of justice by creating a totally uneven playing field. These aren't just minor procedural complaints. They are fundamental threats to how our entire justice system is supposed to work.
A report that analyzed all this correspondence puts it in really blunt terms. It says the alleged actions are not random mistakes, but part of a systematic rigging of games. This analysis concludes that these seemingly small administrative decisions are what can allow larger public predators to flourish, basically by making sure they never have to face a fair fight in court.
And so that leaves us with this really fundamental question. The Prothonotary's office is supposed to be the impartial guardian, the gatekeeper of the court's processes. But when that very gatekeeper stands accused of tipping the scales, of manipulating the records, it leaves us with a deeply troubling dilemma. Who guards the gate?